Good day, class, and welcome to this Introduction to Criminal Justice course. I am Professor Darrell Ouellette, and this will be Lecture 11 in this course. Lecture 11 will be titled Courtroom Testimony and Demeanor. In this lecture, I'll be talking about the responsibilities of a police officer in preparation for court testimony, as well as the police officer's demeanor in the courtroom. This lecture will fall under court action in the criminal justice funnel. Testifying in court is one of the most frightening things you will do as a police officer. As you can see from my title, I'm a retired state police commander, and I've testified hundreds of times in court during my 33.5 years on the police force. I say that testifying is one of the most frightening things you'll do as a police officer. The reason for that is because you are a key witness during the trial. You are on center stage. You know that you're a key state witness, and the direct examination by the prosecutor will be quite friendly, simply because the prosecutor wants to bring out the information you know about your investigation. But following the prosecutor's direct examination, you know that you will be then cross-examined by the defense attorney. Some police officers will tell you that they'd rather go to a bar fight than to testify, or they would rather sit across from their mother-in-law at the dinner table. It can be nerve-wracking, especially the first time you testify in court. But after a while, we become, as police officers, we become trained in knowing what to say or how to act on a witness stand. And when I say trained, you need to, because you're an important witness, you need to sound very believable. And so not only must you tell the truth, but you must look like you're very credible. As a veteran police officer, I can tell you that the best advice I can give you prior to courtroom testimony is to be prepared. Being prepared means doing a thorough job of investigating a case and then go to court with a complete and well-written case report. Another critical piece of advice I can give you is that you should always remain professional as a police officer. Being professional in your everyday duties carries into the courtroom. Always remain impartial and objective in your investigations. By that I mean keep an open mind, be impartial and objective. Not only gather evidence of guilt, but you must also gather evidence which will prove that someone did not commit the crime. It's impossible, or it's difficult to remain objective or impartial once you've concluded the defendant's guilt. If you're positive that a defendant committed a crime, then you will make an arrest, and it's difficult at that point to remain impartial. But at all times you need to remain professional throughout the whole judicial process. Now I've put up a new slide. This slide is titled situations when an officer may need to testify in court. In some of these, you should be familiar with all of these. The arraignment of a defendant. That is where a defendant will appear before a judge to make a plea of either guilty by insanity, or not guilty. Guilty by reason of insanity, or not guilty is what I meant to say. Police officer may be asked a question by the judge during that proceeding. There's no jury. It's just the prosecutor, the police officer, the defendant, and possibly his attorney. And you may not necessarily take the witness stand, but you may have to answer questions to the judge as to why a person was arrested, or why a person did not get bailed, and so on. The judge may do a bail review at that arraignment, or schedule a bail review later on if the bail is quite high and the defense attorney wants to argue to bring or reduce the bail. Police officer will also be testifying at pretrial hearings, hearings like a grand jury hearing, a probable cause hearing. Your testimony at that point will be under oath. And of course, at the time of trial, the police officer will have to, as a police officer, you'll have to testify during a trial. Your role as a law enforcement officer is to investigate crime and to enforce both motor vehicle and criminal laws. As a police officer, you are a fact finder. You're also a truth seeker. You investigate to determine facts concerning the crime, and you are a truth seeker in that you are trying to determine who possibly committed a crime, what possible motive they may have had, what opportunity they had, and so forth. As a police officer, you go where the evidence takes you. And if the evidence takes you to a defendant and there's evidence to support the commission of that crime by that defendant, then you make an arrest. Sometimes a police officer will be convinced that someone committed a crime, but if it's a major crime, the prosecutor may want to hold off on an arrest because you only have one bite at the apple. By that I mean you can only be tried once for a crime, and if you're found not guilty, then you cannot be tried again under the double jeopardy rule. Of course, if it's a hung jury and there's been no verdict, then a person can be tried again under those conditions. Most of the time, as a police officer, you will be a state's witness, because it is the state which is bringing charges against the defendant based upon your investigation. You are a state's witness because the state represents the people. It's the people who bring charges. It's not the victim of a crime. A victim of a crime is a victim as well as a witness, but it's the state or the people of a state which are bringing the charges. We see that a lot in domestic violence cases where the perpetrator, the aggressor, blames the victim for getting arrested. They are blaming the victim as the person bringing the charges, but that's not the case. The victim has alerted police to the fact that a crime has been committed. The police do an investigation and bring charges on behalf of the state. On rare occasions, police officers may be called by the defense to testify, but most often you are a state witness. The defense may call upon a police officer if a police officer has conflicting information regarding the investigation of a lead investigator. If another police officer involved in the investigation finds some contradictory information, let's say a footprint was found at the scene by a police officer that did not match the footprint of the defendant that was arrested, you may be called by the defense to testify to that. That's an example. I'd like to talk for a few minutes now about the relationship between the district attorney, the DA, and the police. The DA relies on police to go to do a thorough investigation, and open communication between the DA's office and the police is important. The DA also relies on the police to keep contact with witnesses on individual cases. As you know, the DA is the lead prosecutor. In every county there's a DA. They are the ones that will prosecute the case. The police are the ones that do the investigation. And because there are a lot of cases that go through the DA's office, it is the DA relies on the police to keep contact with witnesses on individual cases. As a police officer, you must supply the district attorney with a complete report and a complete list of evidence so that information can be forwarded to the defense attorney through rule of discovery. As I mentioned in previous lectures, whatever the state has for evidence, that must be turned over to the defense. If that evidence or that information is not turned over to the defense, then the state or prosecutor cannot present that evidence in court. There are no surprises to the defense in the state's presentation of the case. On this next slide, I've titled this Pretrial Responsibilities by a police officer. Now, as I mentioned a few minutes ago, involvement with the state attorney is important, the prosecutor. A prosecutor can be a state attorney, it can be a county attorney, but they represent the county, they represent the state, the people of the state. Prosecutors can be also federal. And it's important as a police officer to work closely with them. The police officer may also have involvement with a public defender or a defense attorney. A public defender or defense attorney defend the defendant. And as I mentioned a few minutes ago, they will be supplied with a report on the case through discovery. If prosecutors or if public defenders or defense attorneys have any pretrial questions, they should direct those to the district attorney. Because they have a report, the questions should go to the DA's office, not to the police officer. As a police officer, if you're approached by a defense attorney, refer them to the DA's office, because they will capitalize on any conflicting information between you and the DA's office. As a police officer, you'll have involvement with victims of crimes. Your job as a police officer is to also keep victims apprised of how the case is going. Sometimes it takes up to a year for a case to go to trial, particularly in major cases like homicides. The victim's family should be kept apprised of how the case is going. What stage is the case at? How long before trial, and so forth. Police officers are also involved with witnesses. They need to be prepared for testimony also. As witnesses, it may be their first time in court, and it's the officer's responsibility to show them or explain to them how the proceeding will go, possibly take the witness to see a trial beforehand, sit at another trial to see how the proceedings are taking place, the decorum in the courtroom, the professionalism that goes on there. And as a police officer, you may have continuing involvement with the offender after arrest. Usually after arrest, the contact with the offender is minimal because the offender usually gets an attorney, and the attorney will tell the offender not to speak to any to police officers, because anything they say can and will be used against them in a court of law. But there are, on rare occasions, a possibility that you will run into the offender or the defendant on the street, and he may ask a question. If the offender is represented by attorney, you cannot talk with the offender. You cannot ask questions of the offender without the offender waiving his Miranda rights. Now, in this next slide, I'd like to talk about how to prepare for testimony. Preparation for testimony is very important. Remember that in your investigation, your responsibility is to find the truth. Your investigation and your report should also include evidence which points to the defendant's innocence as well as their guilt. Preparation for testimony begins with the first report of a crime. And you as a police officer will be taking notes from the onset. The time you got called to the crime scene, the time you responded, and anything you observed while at the crime scene, or anything you did while at the crime scene. So note-taking is very important. Remember, it's not your responsibility to determine guilt or innocence. That is up to a judge or a jury. Your responsibility is to collect facts and to find the truth. Now, once you've made an arrest, in preparing for testimony, you will review your case file. You will refresh your memory on the report that you did. It's important that you have a good knowledge of the case. You should know the case better than anyone else, even the prosecutor, because you were there. You were at the scene. You did interviews. You collected evidence. If possible, you should revisit the crime scene. That will refresh your memory even more. In preparation for testimony on this next slide, you should have a pretrial conference with the prosecutor. And in that conference, you're going to talk about witness statements, what you have for witness statements, what you have for evidence, what are the weak points in the case, what's a possible defense that the defense attorney will use. The defense attorney will attack the weak points in your case. Now, you also need to discuss with the DA any follow-up not noted in the report. You may have gone back to visit, let's say, the victim of a crime. You may have gone back to visit a victim who is a victim of domestic violence, to just to let the DA know that whether the victim is doing fine or not. How is the victim dealing with having a husband or boyfriend, family member arrested in domestic violence? Will the victim be a cooperative victim or a hostile witness? And during your meeting with the prosecutor, you will discuss the possible order of presenting witnesses, and again, the possibility of hostile witnesses. Witnesses that don't really want to testify because they have some sort of relationship with the defendant, or they're possibly terrified by the defendant. They're afraid for their own safety. They may not want to be there, but they can be forced to testify by the use of a subpoena. Once you arrive at court, you need to check the status of witnesses at the court. You have a list of witnesses that you're going to subpoena to trial. You need to verify their presence before the trial begins, so that the prosecutor will know if there's been any changes in his plan for prosecution. If witnesses have not met the prosecutor yet, you should introduce them to the prosecutor, and again explain the courtroom proceedings as appropriate to the case to the witnesses. Now, it's important that you maintain confidentiality. Do not discuss case with jurors, witnesses, defense attorney, or media. You don't want to release critical information to witnesses. You don't want them to talk about the case, because there may be hidden information that while you're doing an investigation that you don't want the defendant to know. And again, defense attorneys, any questions they may have, refer them to the district attorney's office. And any information in the media should be kept very limited. Again, do not release critical information to the media. Courtroom attire. It's important that you present a professional and neat appearance in court. Normally, police officers either wear a uniform or they're dressed in business attire. In district court, judges allow police officers to wear a uniform because it's not a jury trial. And usually in a district court trial, only the judge is the only person who determines guilt or innocence. But in a jury trial, which is superior court, there is a superior court rule where police officers cannot dress in a uniform. They must wear a business attire, which is either coat and tie. Female police officers usually wear a business suit or dress. And the reason for having this business attire is that there's a concern that the jury will be influenced. Some jury members, the appearance of a uniform in court, the uniform represents truth, it represents authority, credibility, and judges do not want juries to be influenced by the presence of a uniform and the fact that just because a person in uniform is testifying, they want the jury to determine whether that person is telling the truth on their own without the influence of a uniform. Preparation of evidence. It's the officer's responsibility to bring to court the evidence in the case. From the time the evidence was picked up, there's been a chain of custody, meaning that the officer who picked up the evidence had it under lock and key the whole time, unless it was being processed by the crime lab. But even then, it's under lock and key, and everyone who either touched the evidence or transported the evidence will be filling out a continuity tag that is attached to the evidence. But once we're ready for trial, it's the officer's responsibility to bring that evidence to court. Whoever will be testifying to the evidence needs to bring that evidence to court. And again, maintaining a chain of evidence, and the police should have a knowledge of the rules of evidence, how evidence is collected, preserved, transported, presented in court. As the trial begins, and the police officer is asked to take the stand, one of your responsibilities is to verify the physical appearance of a defendant in court. The defendant's appearance may have changed since arrest for the following reasons. The defendant, it may have been a while since the defendant was arrested, particularly in a homicide trial, where it may take up to a year for the case to come to court. During that year, the defendant may have lost weight or gained weight. If he's been sitting in jail and not used to 3 meals a day outside of jail, he may, through sheer boredom or the likeness for the food there, may have gained weight while sitting in jail. Or he or she may have lost weight in the past year. You can bet that a defense attorney is going to want the defendant to be well groomed. You may not know the defendant to be well groomed at the time of arrest, but since the arrest, the defendant will surely have a haircut before trial, will have washed their hair. Defendants aren't normally the most hygienic. They're not the most well groomed at the time of arrest, particularly if you're dealing with a drug user or someone who may be homeless, or someone who is on a crime spree, been on the run from the police. They're not going to be the most well-groomed person at the time of arrest. Sometimes they are. The defendant will also be better dressed at trial than he was at the time of arrest. Any tattoos the defendant may have had are probably covered up now. The defendant may have had gold chains, large chains around their neck at the time of arrest. That type of jewelry will be removed for trial to give a better looking appearance, a more conservative appearance to the jury. And next slide, I'd like to talk for a few minutes now about testifying in legal proceedings. As a police officer, you should avoid using jargon. Your language should be formal. You should be using proper language during your testimony. Do not call anybody dude, or avoid any type of jargon. Use formal, proper language. The secret to acting or looking credible is to maintain eye contact with the questioner. If you look someone in the eye, that shows sincerity. If a jury member is watching you testify and they see you making eye contact with the questioner, it shows credibility, sincerity. You should answer the questions appropriately while on the witness stand. Keep your answers brief. Do not be very clear. Do not speculate on your answers. You should remain objective while testifying. If you cannot clearly answer a question, say if you don't clearly remember something, always add to the best of your knowledge. This is the correct information. When answering questions from the defense attorney, you should not jump into the answer right away. Also, when you're answering questions by the prosecutor as well, do not jump into the question right off. pause a moment, think of what you will be saying. That's critically important, especially when the defense attorney is asking you questions. You may want to give pause for a second before answering, so that if it's not a proper question, the prosecutor will want to object to the question. You should control your emotions on the stand. By that I mean you should avoid arguing or giving aggressive replies if you're not happy with the questioning by the defense attorney. Do not interrupt the defense attorney while he's asking questions. Do not interrupt the prosecutor either. Most questions can be answered with either yes or no. I mentioned brevity. If the questioner asks you to expand on your answer, then you are allowed to explain your answer further. You need to only give factual information. Only guess or estimate when asked to do so. Again, control your emotions. You are an objective witness. Do not get angry with the questioner. Do not cry, laugh, yell, or refuse to answer a question. Now, the defense counsel or defense attorney will use different tactics. During the trial to get you to lose your professionalism. They'll want to badger you with questions, accuse you of wrongdoing, of a fault. They'll accuse you of a faulty investigation. They'll accuse you of focusing only on their client and no one else. That you had blinders on during your investigation, and that once you made up your mind that the client was possibly guilty, that you only focused on their client. A good way to answer those types of questions is to explain to the defense attorney that your investigation, the evidence kept leading to the offender, and that's why he was arrested. The defense attorney may use another tactic of rapid-fire questioning. Ask a lot of questions in succession, or be quick to ask the next question after they've asked one. The way to combat that is to just relax. The judge will not allow rapid-fire questioning. The defense attorney is only allowed to ask one question at a time. And by pausing after that question, it prevents the defense attorney from this tactic of rapid-fire questioning. Rapid-fire questioning is used to confuse a witness. The defense attorney will attack weak points in the case, and that's part of the trial. Every case has some weak points in it, and sometimes those can be explained. There may be a possibility that a defendant has an alibi, and you may need to bring witnesses in to talk about the alibi. But if you present the information to the jury should make an educated decision as to guilt or innocence. Sometimes the defense attorney will act overly friendly, particularly before the trial starts. They'll be overly friendly to you in the hallway, just to give you a false sense of security, thinking that that will continue into the courtroom. And sometimes police officers are taken off guard by that. Use of notes when testifying may be examined and used by the opposing counsel. If you bring notes up to the witness stand, anything you carry up there can be examined by the opposing counsel. I recommend that you only take your formal report up there with you. If you write in the margins or do anything to your formal report, that can be examined by the defense attorney. I would suggest bringing up a clean report. At times, it's perfectly all right to request that you look at your report to answer a question. Remember now that in a major investigation, your report may be quite thick, and it's impossible for you to memorize or know every specific detail of your investigation, and it's perfectly acceptable to ask the judge to pause for a moment so you can look at your report to refresh your memory. Now, when testifying, in order to appear to be credible, as I mentioned a few minutes ago, maintain eye contact with the questioner when the question is being asked, but as a witness, you should also give your answer to the jury and make eye contact with the jury. If you recall or can remember, people that you trust the most are people that look you in the eye when talking with you. A person who doesn't look you in the eye may have something to hide. If you're having a conversation with someone and it's an intense conversation, it may be an intimate conversation, it may be a conversation where there's important information exchanged. If a person is not making eye contact with you, it gives the listener a thought that maybe the person is not being completely truthful. This is important when testifying on a witness stand. Listening to the question, making eye contact with the questioner, and then giving your answer to the jury. Usually there are 12 members that sit on a jury, and trying to make contact with all 12 on a given question is impossible, but at least try to make eye contact with each one of them, at least look in that general direction. During your entire testimony, make eye contact with them at least a half a dozen times. You may not, as I said, you can't bounce your head from juror to juror while answering each question, but do not dwell on one juror, do not dwell on two jurors, but try to make contact with all 12 at some point during your testimony. And try to do it at least a half a dozen times on each one of them. That will make them feel like they're important, that you're talking to them specifically, and it makes you look more credible. Okay, so a quick review. You're on the witness stand, you're answering questions, you're making eye contact with the questioner, you're delivering your answer to the jury, making eye contact with them. If there's no jury, look over at the judge when you're giving your answer. He may, or she or he may have their head down, taking notes during the trial, but the fact that you're sitting just a few feet from the judge to the judge's left, they feel your presence, they feel you looking at them, they feel that you're talking to them. It makes them feel more important. It makes you look more credible. Be professional in the courtroom. Do not joke. Do not laugh. Do not, while you're sitting in the courtroom, the jury members will usually be able to pick out who the police officers are. They're the ones with the military-style haircuts. They're the ones that are usually dressed the most professional, besides the attorneys. Do not chew gum. Do not giggle. Do not laugh. Do not talk unnecessarily. The only person you should be talking to in the courtroom before giving testimony is to the prosecutor. The prosecutor may come over to you and whisper in your ear. They may need to have a witness brought forward, or from the hallway they may need to clarify a part of the investigation. So sit in a courtroom like you would sit in a church. Be respectful of the surroundings. Be respectful of the procedures that are taking place. And when you are asked to take the witness stand, do not loiter. Walk at a good pace towards the witness stand. You're going to be asked to raise your right hand to swear to tell the truth, the whole truth, and nothing but the truth. And once you're done your testimony, if you look at this slide, I've posted different steps. You should leave the witness stand quickly and quietly, just like you took the stand. You should leave in the same manner. Do not linger to talk with the prosecutor unless he wants you to. Sometimes you'll be asked to sit at the prosecution table. If you're the lead investigator in a case, the prosecutor may want you next to them at the state's table so that you can give info on the case during the trial, just like the offender sits next to the defense attorney. You're allowed to sit at the prosecutor's table if you're the lead investigator in the case, because you know the case better than anybody else, and you're an asset to the prosecutor. If you're not sitting at the prosecution table and the prosecutor wants additional information under number 3, they may pass you a written note. You should have a minimum amount of display as far as any conversation or notes being passed between prosecutor and yourself. You don't want to give the impression to the jury that you are a team player and this is a strategy that's being conducted in the courtroom. Once you leave the witness stand, you may be excused as a witness, particularly if you're segregated. Some police officers are not allowed in the courtroom. Some witnesses are not allowed in the courtroom. They're called one at a time. So if you're asked to leave the witness stand and to leave the courtroom, do not loiter to talk or gossip with others. And in closing, I'd like to say that under no circumstance should you ever speak to a juror if this is a jury trial. Speaking to a juror is a cause for a mistrial. It's not acceptable. Information that jurors get from a trial should only come from a trial, from witnesses that are under oath. In talking to a witness in the restroom or at lunch, if they're allowed to have lunch outside the courtroom, is not acceptable. It's a no-no. Again, it could be a cause for mistrial if this should be brought forth. Thank you and have a good day.